Welcome to Making It Last, where we share ideas to help families tackle major issues. I'm your host, Regina DeMeo, and with me today is Anthony Fatemi, who's been helping people with immigration issues for over 15 years. Thanks so much for being here, Anthony.
Good morning. Thanks for having me.
Absolutely. So we've been hearing a lot about this immigration reform, and I kind of wanted to pick your brain and get a better sense of what is everybody talking about?
I'm going to try my best. There is a 900-page bill that is being discussed in Congress these days, and the goal of this bill or immigration reform is to try to find ways to have these undocumented individuals in the United States to become legalized. First, to obtain their green card, which is called Registered Provisional Immigrant, RPR, and then after 10 years, hopefully, if they're a good boy or good girls, to get their citizenship. And another element is to secure our border, which we're not going to discuss too much at this juncture. I'm going to focus the discussion primarily with the eligibility of obtaining your green card, and then later on your citizenship, and then talk about a little bit about the employment side of this provision. Let me start by stating that there are 5 ways that an individual can obtain his or her green card.
Which you need in order to work, am I right?
Absolutely,
yeah.
which you need to order to be able to work and to be able to freely travel. And also you need to have your green card either 3 years, it depends the way that you have obtained your green card, or 5 years before you become eligible to naturalize. And there are 2 ways you can become a U.S. citizen, one by naturalization, one by birth. So let me go back. There are 5 ways that one can get their green card. Okay. Asylum, lottery, employment base, family base, and a special act of Congress. And we're going to emphasize on a special act of Congress. This is exactly what is happening right now. So Congress trying to enact a law to provide these undocumented individual some sort of a status. What are the criteria for this individual to become eligible? The first and foremost important element is that you have to be in the United States prior to December 31st, 2011. So if you have not been here since then, this provision will not apply to you.
Okay.
The other criteria is that you cannot be convicted of any felony conviction. If you have a felony conviction, pretty much you're kicked out of there. I mean, there are ways that immigration attorney can help you if you have a conviction to make you become eligible through what is called a post-conviction relief, but I'm not going to discuss that at this juncture. We'll discuss it at further time. But if you have a felony conviction, you may kiss it and goodbye. If there are 3 or more misdemeanor, also you're not going to be eligible for this program. In addition, if you have voted in a local or a general election, again, you're kicked out of this program. So you got to make sure that you have resided in the United States prior to December 31st, 2011. Do not have any felony or 3 misdemeanor conviction, and you have not voted in any local or general election. So if you have not done any of those, you've been a good boy and a good girl, you become eligible for this program.
Okay.
So what you need to do, once the law is in effect, you know, this is just a discussion, we don't know whether this is going to happen or not, but once the law is in effect, you pay a $500 fee and also pay all your back taxes. So if you owe any back taxes to the government, you must pay that.
Oh, wow.
Or you must make arrangement with IRS to make payments. So either pay your back taxes or make some sort of arrangement or contract with IRS to pay your taxes. So once you've done all of that, then you're eligible for RPR, a Registered Provisional Immigrant, and then you will receive that card if there is such a thing. I call it a green card. It's very similar to a green card. Once you obtain your green card, you're eligible to work anywhere you want. And also you're eligible to travel. but you're not eligible to receive public help.
Okay.
So you have to be careful of that. And this will give you a 6-year period of lawful permanent residency or conditional residency or registered provisional immigrant status. During these 6 years, if you have not committed any crime, if you have not done anything bad, if you have been paying your taxes and you have not committed any deportable offenses, then you have to renew this RPI. You have to pay another $500 fee.
Okay.
This is the provision right now. We don't know whether the $500 is going to stand or is going to be increased. They're talking about the fees and structure right now. You pay another $500 fee, and then you get an additional 4-year.
Okay.
Additional 4-year. So what's happening with this provision, as I stated earlier, there is a border security element to it. So they give you this 4 years, and during this additional 4 years, the government is trying to determine whether the borders are secure, because they are talking about how to secure the borders and prevent people from crossing. So if that's into play and everybody in Congress is happy, then you have to pay after the 4th year, so you have 10 years of this registered provisional immigrant or conditional residency or lawful permanent residency. You apply, you pay a $1,000 fine. Again, you have been paying your taxes and there are no deportable offenses. Mm-hmm. You're a good boy and a good girl. So you apply, and also you got to be able to understand, read and write English and know the history of United States. So if you're able to demonstrate that, then they said you're fine, your 10 years has lapsed, and then after that you have to wait 3 years in which you become eligible to get your naturalization, become a U.S. citizen.
So I have a question, because is there an age limit, for example, of this need to read and write English? Because my grandmother never learned English. She was here for over 40 years and never learned to read or write English. But she somehow did become a U.S. citizen in the end. So is there an age factor?
Yes. Yes. If you are above age of 55 and been in lawful permanent residency for at least 20 years, and or you are above age 55 and been in lawful permanent residency for at least 15 years, then the history test and the requirement could be conducted in your own language, in the language in which you were born. So it doesn't have to be in English. Maybe that's why your mother found a way to overcome that.
Right. Right.
And of course, we're not going to get into that, but there are other exceptions for individuals with disability, cognitive disability. There are various individuals that do have cognitive disability and they're not able to learn something new. So there is a provision for that if you're able to get certification from a USCIS certified physician or psychiatrist, psychologist, they're able to waive the English portion of the requirement and the history. Mm-hmm.
Yeah, it's funny because I don't want to take too much time away from what we have to cover, but it brings up an interesting reaction in various people. Like, some people are so indignant of the fact that someone who doesn't know how to read or write English could actually become a U.S. citizen. And meanwhile, I think to myself, hello, people, like, this is how the country was created, right? People came to the United States. No, very few people are actually like Native Americans, right? Most of us in our backgrounds have had someone immigrate, over to the United States in order for us to be where we are today. But the immigration laws really seem to trigger very visceral responses in some people, and I just don't understand that. Have you seen that? Well,
there are many elements to that, as you stated. This is a country of immigrants, but slowly they're trying to close the border. We're getting crowded in here, and with all the problems we've been having from outside, so there are different views in response to that. But there are ways that you can challenge and overcome the inability to learn and study new way of speaking, in this case English, to be able to get your naturalization. But even though they are closing the door, they're leaving some of the door for individuals who have some issues to be able to become naturalized anyway.
Makes sense. So, in my world of divorce law, there's a lot of questions that come up about, someone's ability to remain in the United States if they're, they're here because of their spouse. So a lot of people get very, very nervous, like, oh my God, maybe I can't get my divorce because if I do, I'm going to have to leave the country. Do you see that a lot?
Yeah, I see that a lot. As I stated earlier, there are 5 ways one can get their lawful permanent residency green card. One is through family-based petition. So through family-based petition, I think you alluded to that. If you are a United States citizen, you want to bring your spouse into America and she's or he's from somewhere else, you have to petition for her and him to come here. Once you petition for this individual to come here, once they arrive in the United States, they have what is called a conditional residency. It's good for 2 years. Okay? And what I have seen throughout my practice is in some of these cases the cultural gap are so large that when they bring a spouse into the United States, it creates a lot of problem. It could be religion, it could be culture, it could be the food, it could be anything. So that friction creates a problem for the family, and the family nucleus falls apart. Once it falls apart, then one has to file a complaint for divorce. And that's where the problem occurs for a immigrant spouse. What he or she must do during the course of conditional residency. Can he or she stay here? Well, creates a lot of problem. So I don't know, where would you like me to start, but let's say you bring your wife to America and the conditional residency has been granted. During the first year, things are so horrible, and she moves out.
Right.
She moves out and she files for divorce. What happened to her immigration status? Well, if she's able to show that the marriage was put together in good faith, and the marriage was put together for love, respect, creating family, and not to obtain immigration, a legal immigration benefit for her. Once she has obtained her divorce decree, she can go to immigration services and request a unilateral petition to remove the condition.
Okay.
The idea is you have to remove the condition of residency to become a permanent resident. And this has to be done jointly with your spouse. But if you're not with your spouse, you have to do it unilaterally. The way that you can do it.
So it can be done?
Of course,
Okay.
of course. It can be done, but the standard is high because you have to show to immigration services that you did not commit fraud,
Right.
you did not enter into this marriage to come to United States to get your green card. Because if that's the case, you might as well say goodbye.
Right.
And not only you go back, but your spouse may be subject to $250,000 fine and some prison
Wow.
time. Sure, yes.
Wow.
So anytime we get clients coming to our office, and we do have lots of clients who come to our office to adjust status or bring a spouse through consular processing, we are very careful to investigate the background and discuss the case with them and explain the implication of any fraud. So
Right.
if we see anything coming that way, we either don't accept the case or we let the client that you should stay away from marrying this individual.
Right. We're going to take a short break, and then we will be right back.
Thank you.
My name's Reggie. Just recently, my wife and I took in her sister's children. And we already had 4, so I went from becoming a family man to a man with a bigger family. You can't eat love, so I don't know how I'm going to feed them tonight. How was that, Reg?
think I look more like Denzel.
That's cold, man.
Play a role in ending hunger. Visit feedingamerica.org/hunger and find your local food bank.
Welcome back to Making It Last, where we share ideas to help families tackle major issues. I'm your host, Regina DeMeo, and with me today is Anthony Fatemi from the immigration law firm in
Gaithersburg, Maryland.
Yep.
Correct.
Thanks so much for being here.
You're welcome.
So, we're talking about divorces, and unfortunately, sometimes when emotions get very high, there's oftentimes a protective order that is also, brought on simultaneously with the divorce. So how does a protective order impact someone's immigration status?
I believe hugely. There are, as I stated, 5 ways you can get your green card, but there are substantially more ways that you can lose it and get deported. So you better be very careful. Conviction-based grounds of deportation are very important for somebody who either a lawful permanent resident or undocumented. So they have to be very cognizable of that. There are 52 ways that one can be deported based on a conviction of a crime. I'm just going to go over few of these right now. As far as criminal grounds are concerned, if you're convicted of an aggravated felony, a crime of moral turpitude, controlled substance abuse, firearm or destructive device conviction, and domestic violence, these are conviction criminal grounds of deportation. So let me focus on domestic violence. If an individual is there is a finding of facts that an individual has committed abuse, and the individual who is seeking protection is one eligible for protective order. Once the respondent is found that has abused the petitioner, he or she can or might as well get his one-way ticket back to where he or she is from, because as I stated clearly, this is one of the criminal grounds for deportation, and Immigration Services, Immigration Custom Enforcement Office of Immigration Services take these very seriously. Any crime against a child or a woman are taken seriously by local government and federal government. So clearly that would trigger a deportation to where you're coming from. A one-way ticket to where you're from, and once you are detained by immigration custom enforcement, they're going to find a room for you somewhere near Ocean City. Okay, and I can assure you, it's not an ocean view or a water view. It's none of that. It's close to Ocean City. If you're lucky, if they don't have a room, all the rooms are booked. They're going to transport you to either Arizona, Texas, or Louisiana. And I can promise you, rooms over there are not ocean view or ocean front either. So why are they doing that? They're doing that because they're getting you closer to where you're from, so they can take you to either, for instance, if you're from Central America or South America, and then they can transport you much easier to that country. So be careful with that. So I would suggest that if a domestic violence situation is occurring, cool it down, get out of the situation, hopefully things get cooled down. But if for any reason you had to go to court, do not let the judge find that there is a finding of fact that there was abuse. Just enter into a consent order and walk away from it.
Right, we do that a lot. We negotiate stay-away orders without a findings of wrongdoing.
I think that's the best case scenario for even a U.S. citizen, because my understanding is if there is a finding of fact, and in some situation, if that individual, for instance, has a security clearance, it would trigger a problem with the Department of Defense, and they have to go back to the Department of Defense and explain what happened. So negotiate a consent, and don't let the judge find there was a finding of facts of abuse.
Right. So when someone's hiring you to help them through the process, either to obtain a green card or to go through the naturalization process, what kind of fees are they looking at? What kind of fee structures do you have?
Well, generally in state of Maryland, that's where I practice, there are three fee structures: contingency, hourly, and flat fee. There has been a general practice in immigration area that you either charge a flat fee or hourly fee. The reason that most, if not all, immigration attorneys charge or take the flat fee based approach is due to the number of cases they have done. And most of these cases are repetitive. They're very similar in process. Of course, they are substantially different in facts and individual that we're helping, but in the process they are somewhat similar. So we have an idea that how much work we have to put into this project, and we charge a flat fee. There are attorneys that I know of charge an hourly fee, and that's perfectly fine. And there are attorneys that use a hybrid approach. There is a flat fee up to certain amount of work. Anything beyond and above that would kick in an hourly fee structure. So these are the ways. Generally, we don't do contingency fee in these type of cases.
Right. Makes sense. I mean, I think that more and more of the legal world is heading in that direction, sort of like a flat fee approach, and then if things get beyond the norm, okay, then you're going to be charged an hourly rate. But like for a prenup, I can pretty much predict how much time that's going to take me. I could flat fee that, and then if it starts to get super complicated, then the hourly rate kicks
I
in.
think that approach, the hybrid approach, would be not only protecting your client, because you want to really protect your client and do whatever necessary for her or his best interest, but also protecting the firm. So I think it's the best approach, and we have been modifying our fee engagement agreement recently these days, and adopting the more hybrid approach.
Makes sense. So I don't know if you see this a lot, but I think a lot of people come here like on a student visa or a work visa, and then it was never probably even their intention to stay, but they wind up liking it here and they decide they want to stay. So where in the process should they contact you? Like, at what point should they say, do they wait until they graduate before they or like, I imagine this is very time sensitive, and I imagine waiting until your visa is like a week from expiring is not a good idea.
Well, I agree with you. What one must do, a student who's on an F visa, that's what it's called, an F visa, a student visa, we recommend that he or she contact an immigration lawyer about a year before they are completing their academical program. Okay. And why do you want to do that? If you have intention to stay here, there is what is called a optional practical training, OPT program, for students who are concluding their academical program or near concluding their academical program, can obtain permission to work in the field of the discipline in which they've been studying. So that's a great opportunity, because you avail yourself to an employer, and if an employer likes your work product, then that employer may be willing to sponsor you to stay in the United States. That approach could start from a H-1B. It's an employment-based petition, non-immigrant visa. And if the employer continue liking you and you continue providing a good work product and good ethical professional standard at your workplace, the employer may sponsor you through what is called a perm to get your green card. Again, remember there were 5 ways to get your green card: employment-based petition. This is what is called an employment-based petition. So if they come here to just study and realize, wow, this country is beautiful, in which it is, and the opportunities are vast, which they are, there is a way for them, they can explore employment, and then hopefully the employer can sponsor them to stay longer.
So what's that process take? Like 6 months? If you're thinking, okay, I have an employer that wants to sponsor me. I mean, hopefully, usually the employer pays for the fees at that point, right?
Yes, the employers shall pay all the fees to sponsor the employee to secure a position at the employer's business. The process usually starts April 1st of that calendar year. Let me give you an example.
Okay.
If an employer like to hire a F student, and she has a 4-year college degree, a 4-year college degree
right.
At a particular discipline. Let's take IT, information technology, and let's say Cisco, and Cisco would like to hire this individual that has a 4-year college degree. So the process opens up April of every year. So April 1st of 2003, the window opened up for the employer to file a petition to have this individual be hired working for the employer October 1st of the same year.
Okay.
So if the employer filed a petition in April 1st, 2013, and the petition has been granted, then the employee is ready to work October 1st, 2013. And hopefully the student is using her OPT to stay in a status. Therefore, we can file to change the status from F1 into H1B.
Okay. And now, is it just paperwork? Is it just like a matter of, like, let's say I wasn't a U.S. citizen and I came to your office and I just filled out whatever paperwork I needed and then I'm done? Is that, or do I actually have to appear for a hearing? Like, is it hearing intensive?
For what petition? Getting a H1B process? No, there are not usually any hearing in obtaining H1B, which is a work visa.
Okay.
But if you want to get your green card, if you're here, just give you an example. If your spouse is here and you're filing, petitioning, sponsoring for her to get her green card, yes, generally there are interviews involved.
Okay.
You have to go to the local office in this area. Baltimore District Office is a local office, and then you have to conduct interviews.
And do the attorneys usually go? I mean, is it possible for somebody to navigate this process by themselves? I don't feel like I could, and I'm an attorney. So,
well, we never tell our clients that you can do this on your own. In my opinion and my experience, it's very dangerous.
Yeah.
The immigration officer may ask you questions that you feel obligated to answer, but really you don't have to. Mm-hmm. The questions are not relevant or legal to the petition, and that may create a problem for your case. So we recommend our clients, when they come to our office, first of all, they have to hire us to allow them to do the work. Second, we always attend interviews.
Okay.
Prior attending interviews, we always prepare our clients for the interview as well.
Makes sense. So if somebody wanted to contact you for further information, how would they do that?
They may go to our website, www.fatemilaw.com. We have lots of information on our website. If they want to make an appointment to see us, they can contact us at 301-519-2801.
Great. Anthony, this has been fantastic. Thank you so much.
Thank you so much for having me.
Absolutely. So if you have any show ideas or would like to be a guest, please feel free to contact me at genxmarty@gmail.com. Thank you so much for tuning in, and we'll see you next week on Making It Last.